right, I'm gonna let Mr. Crystal know that his case, Ms. Adams, Mr. Crystal was adjourned. Do we have a date for that?
Checking.
All right, Mr. Crystal, good morning. So
Good
in the
morning.
matter of the people of the state of Michigan versus Alan David Crystal, file number 22-20896FH. Sir, Mr. Goldstein did adjourn this morning. I believe it's because he's in a trial. So go ahead and give his call or go ahead and give his office a call, okay?
I will do that. Thank you very much.
All right, thank you, sir. All right, so Mr. Cortez, we're just waiting for someone to come in, so we'll wait for that. All right, in the matter of the people of the state of Michigan versus Gary Michael Lentz, file number 23-21231FH. Mr. Lentz, I show that you are self-represented, is that correct?
Yes, Your Honor.
Okay, now, Mr. Lentz, do you understand that you do have a right to have a court-appointed attorney represent you at this and all subsequent hearings because you're an MBOC inmate? You are indigent and entitled to court-appointed counsel. Do you understand that?
Yes, ma'am.
Okay, and do you wish to proceed without counsel? Or would you like counsel appointed to represent you?
Well, the main issue is that I'm being, I try to present my issues, I guess, in court, didn't give my motions. I got certified mail with them, so I mean, the court's not even.
Sir, I can't hear a word you're saying, so you need to slow down. You're talking really fast, and I need you just to answer the question I asked you. Do you want counsel appointed to represent you? Yes or no?
I mean, it's not that easy, but yes, in general terms, yeah. Well, like I was saying is that, I mean, I'm not having any fair due process regarding like the filing of my motions.
Okay, I'm not asking you that question, so I'm not gonna, what my question is, do you want a court-appointed attorney?
Yes, because the circumstances out of my control, yes, yeah.
Okay, so you would like to have an attorney appointed to represent you?
Yes, yes.
Okay, so here's what I'm gonna do, Mr. Lentz. I'm going to appoint the public defender's office to represent you. And what I will do is set this over for 2 weeks to have that attorney have an opportunity to speak with you. Did you previously have court-appointed attorney, or have you declined it up to this point?
They were ineffective, where they weren't doing anything really at all for me.
Okay, well, it's going to be the same office, so you know, and I found
Is
that.
they have a different attorney from that office?
I can't hear you.
Is there a way to have a different assigned attorney from that office?
No, I have no authority or control over the public defender's office.
Okay, other than that, I was trying to talk to the prosecutor about a disposition. I don't know if,
Well, okay, so, sir, you're asking for court-appointed counsel, and I'm going to then appoint court-appointed counsel, correct?
yes, ma'am, yeah.
Okay, so today is your arraignment. Do you want me to adjourn your arraignment 2 weeks to have counsel present with you? Or do you want me to arraign you and then appoint counsel?
Just adjourn it,
Hey, Jeff, check you on Gary logged in on Zoom.
Mr. Bennett, you are not muted.
Gary logged in on Zoom.
Okay, so you'd like me to adjourn the arraignment?
yes, ma'am, yeah.
Okay, so Ms. Adams, I am going to set this over to February 22nd. That's 2 weeks from now, sir. And that'll give us enough time to, one, writ you in from MDOC via Zoom, and 2, get court-appointed counsel to represent you. So I'm going to adjourn the arraignment to February 22nd, and I'm going to appoint the Public Defender's Office to represent you. So, Mr. Lentz, we will see you back here on February 22nd at 8:15 in the morning, all right?
Yes, Your Honor, yeah.
Okay, very good. Thank you, Mr. Lentz. We'll see you back on that day.
Yes, ma'am.
All right, you're all set. So I'm gonna, they'll disconnect you, I'm sure, in a minute. All right, Mr. Bennett, you were, let's see, there's so many people. Shumate, Gary Shumate. Do you have them with you? I've got a couple people with no names on their devices, so let me figure out who they are.
Yeah, that was him actually calling me to ask when he should log in, so he said he was logging in.
Okay. And Mr. Shand has Mr. Lafave. Okay. All right. All right, I have somebody on a Galaxy device with glasses sitting in, looks like their kitchen. There's 2 people, gentleman in an orange shirt. What is your name, please?
My name is Gary Shumate.
All right, Mr. Shumate, thank you. Let me get his name in there for you, Mr. Bennett, and then let me find out who this other lady is. All right, what's her name? I know who she is. Name, I can't believe me think of it right now. All right, so in the matter, the people of the state of Michigan versus Gary Edward Shumate, file number 22-21076 FC. File. S. I have Jeffrey Bennett appearing on behalf of Mr. Shumate, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. It looks like this is the first pretrial in this matter. So, Mr. Bennett, how would you like to proceed today?
Yes, Your Honor. I hate to correct you. This is the second pretrial in this case, I believe. We had put it till today. I had expected to get a motion to quash completed to also argue today. I did not do that. So I would request an adjournment for a few weeks so that I can file the motion to quash.
Okay, the reason I thought this was the first pretrial is because no one did the stipend order to adjourn today. So Mr. Bennett, you'll need to do a stipend order adjourning from November 30 to today, and then one from today to the next date. So you want to do a motion to quash. Ms. Adams, how long are you going to need to prepare your motion, Mr. Bennett?
2 weeks.
Well, okay, I don't have a motion docket available until probably April 5 or April 12. But I would set them at 10:30, and there's a jury trial that day. I mean, I have jury trials every day right now. They just don't ever go. But April 5 or April 12 at 10:30.
April 5th would be good.
All right, so, and I'll set it a little bit later, so because of my arraignments and pre-trials. So I'll set it for another pre-trial and motion on April 12 at 10:30, and you can do the stipend order to adjourn, and then also the notice of hearing for your motion. And I'll continue the not guilty plea on behalf of your client, and his bonds continue.
Thank you. Mr. Sneed, do you want me to email this to you for signature?
You can sign with my permission. Thank you.
Thank you, Mr. Sneed.
All right. Okay, thank you, Mr. Bennett, Mr. Shumate.
Thank you,
Thank
ma'am.
you, Your Honor.
All right, so Mr. Shand, well, we're a little bit early, so you were set for 10:30. So Randy's not here yet, but he will be. Sure.
I sent him the wrong Zoom number.
Okay.
So I just corrected it. So he should be logging in here momentarily.
All right, we have a couple people. Mr. Shumate, I'm going to go ahead and disconnect you. All right. So Miss Underwood is not here, so I can't do Mr. Dodson. Lisa Hannibal. Malaro, I'm looking for you, Dawn. Bridget Reinhardt. Okay, no, that's Sam. I don't have Sam. Oh, I have a Tammy. That would be Tammy Bannon. Anthony Haybecker. Okay, that's a PPL. I don't have anybody in my waiting room for you. And Becky on the jail list. Let's see who Rhonda or Dawn has. Dawn has.
I have Jonathan Jeffords, Milton Rembert.
Becky, if we could get Mr. Jeffords and what was Rembert?
Milton Rembert.
Yep, we got Jeffords is in jail, so we got him.
Yep.
All right, I got Randy Lafave. All right, Mr. Lafave. All right, let me grab your file. All right, this is in the matter of the people of the state of Michigan versus Randy Lewis Lafave. We have two files, 22-21138FH and 22-21139FH. I have David Shand appearing on behalf of Mr. Lafave, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for a pretrial conference in this matter. Mr. Shand, where do we stand today?
I just talked to Isaac. We had discussed this before. This was a really strange case because he had two felonies in front of district court. We were going to knock them down to misdemeanors, but that would have deprived him from being back up into your drug treatment court. So that's why we ended up coming up to you, and now we're prepared to plead to two misdemeanors here so he doesn't get kicked out of your treatment court because you've done wonderful things for him and he's doing
so on file. Great. So on file number 22-21138FH, will there be an amended information filed with account 2, Mr. Sneed?
Yes, there will be, Your Honor. It'll be use of meth.
All right, and that's 1 year misdemeanor. And then what about file number 22-21139FH?
We'll submit an amended with account 2 for use of cocaine.
Correct, Your Honor.
Is that correct, Mr. Shand? Okay.
Yes. This is what we've been trying to do. We had to find a way to do it to keep him in your court.
Not a problem. All right, Mr. Lafave, you want to raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Oh no, are you sick?
Forgive me, I'm having some sort of, I think, reaction to something I ate. My throat and my mouth is swelling up.
You got Benadryl?
That makes it worse, I think. For me, I have an adverse reaction to it.
All right, you need to go to the doctor as soon as we're done here, Mr. Lafave.
I planned on
All right. So, Mr. Lafave, have you heard the statement of your attorney and the prosecuting attorney? And is it your intention on file number 22-21138FH to plead guilty to count 2 use of methamphetamine, which carries a maximum penalty of up to 1 year in jail?
Yes, Your Honor.
And on file number 22-21139FH, Mr. Lafave, is it your intention to plead guilty to count 2 use of cocaine, which also, that's a 1 year too, right, Mr. Sneed?
Yes, it is, Your Honor.
Which also carries a maximum penalty of up to 1 year in jail. So is it in your intention to plead guilty to that one as well?
Yes, Your Honor.
Okay, are you satisfied with Mr. Shand as your attorney and the advice that he's given you?
Yes, Your Honor.
All right, other than bringing it up here for a misdemeanor, neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed any possible sentence with the court. Is that correct, Mr. Shand?
Correct, Your Honor.
And Mr. Steen?
Yes, Your Honor.
Other than
Mr.
his
Lafave?
ability to stay in your treatment court.
I think he's transferring to another one anyway. So is that correct, Mr. Lafave?
Yeah, I'm going through the process.
I know, but is that your understanding? No agreement's been made with me? Okay.
Yes.
Now, if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial, have witnesses against you appear at your trial, and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Lafave?
Yes, Your Honor.
Okay, I'm trying to get through this fast so you can get to the doctors. Do you understand that any appeal from the conviction and sentence would be pursuant, or conviction and sentence pursuant to the plea will be by an application for leave to appeal and not by right? Do you understand that, Mr. Lafave?
Yes, Your Honor.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
No, Your Honor.
All right, so Mr. Lafave, on file number 22-21138, how do you wish to plead to the charge that on or about February 22nd of 2022 in the city of Adrian in the county of Lenawee that you did use methamphetamine, guilty or not guilty?
Guilty, Your Honor.
All right, and on file number 22-21139FH, Mr. Lafave, how do you wish to plead to the charge that on or about April 6th of 22 in the city of Adrian in the county of Lenawee that you did commit the offense of use of cocaine? Guilty or not guilty?
Guilty, Your Honor.
All right, has anyone made any threats or promises to you to induce you to plead guilty to this charge?
No, Your Honor.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that
I'm done. Sure. Yeah.
that were not disclosed to the court on the record during this hearing, but that it was not your own choice to enter the plea? Do you understand that?
Yes, Your Honor.
All right, is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty other than drug court? Mr. Shand?
No, Your Honor.
Mr. Sneed?
No, Your Honor.
Mr. Lafave, has your attorney promised you any particular sentence or estimate what your sentence will be?
No, Your Honor.
Is it your own choice to plead guilty?
Yes, Your Honor.
So, Mr. Lafave, we're going to go to file number 22-21138FH. On February 22nd of 2022, were you in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
And did you have in your possession methamphetamine?
I did, Your Honor.
And did you use that methamphetamine?
I did, Your Honor.
And you had no legal right to do that, correct?
That is correct, Your Honor.
All right. And on file number 22-21139FH, Mr. Lafave, on April 6th of 2022 in the city of Adrian in the county of Lenawee?
Yes, Your Honor.
And at that time, did you have in your possession heroin?
Yes, Your Honor.
And was it heroin or cocaine?
It was, I was, to be honest with you, I was led to believe it was one thing, but it could have been anything. Everything's
Okay.
pretty much the same nowadays.
Yeah, so would you agree though that it was heroin that you actually had in your possession and used?
Yes, Your Honor.
And for purposes of the plea, you're pleading to a use of cocaine, which is a 1-year misdemeanor, correct?
Yes, Your Honor.
And you had no legal right to possess that, is that correct, Randy Lafave?
Yes, Your Honor.
All right. Mr. Sneed, has the court complied with MCR 6.302 B, C, and D?
Yes, people are satisfied.
And Mr. Shand?
Defense is satisfied, Your Honor. Thank you.
Excellent. I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. Mr. Lafave, the pre-sentence report, because it's a misdemeanor, has to be done by district court, but I will be sentencing you, okay? Are you in Ann Arbor right now?
I am.
Okay, so I'm gonna need you to come to Adrian between 8 and 10 a.m. on Thursday morning and go to the first floor district court probation, okay?
That's okay.
And-
I'll be there Thursday anyways. So.
Okay, and meet with them and follow their instructions. They'll prepare a pre-sentence report. They'll provide it to us. We'll provide it to Mr. Shand, and he'll review that with you before the day of sentencing. Now, Mr. Lafave, do you have any objection to doing your sentencing over Zoom, or do you want to be in person?
I don't have a preference. Zoom kind of.
Okay. So, all right, we'll do Zoom sentencing. And Mr. Shand, are you available April 6th at 8:15 in the morning for a Zoom sentencing?
Yeah, that would be fine, Your Honor.
All right, we will set that for April 6th at 8:15 for sentencing. And Mr. Lafave, get to the doctors right now.
Okay, I just want to say April 6th will be my 1 year.
Awesome. All right, thank you.
Yeah, we can tell
All
by
right. All right, thank you, Mr. Shand. Who do I have joining me from the jail? Mr. Jeffords?
Yeah.
Okay, so Miss Van Duzen, let me find that. Miss Van Duzen, do you need a breakout room?
Yes, Your Honor.
Okay, so let me call it real quick. This is in the matter of the people of the state of Michigan versus Jonathan Jeffords. We have two files, file number 2018-19058 FH and file number 21-20628 FH. I have Dawn Van Duzen appearing on behalf of Mr. Jeffords, and I have Christopher Fleming appearing on behalf of the people. So I'm going to open up a million breakout rooms because I know we're going to need them. And Miss Van Duzen, I'm going to change the screen name of Mr. Jeffords so I don't lose him. And I will put you and Mr. Jeffords into a breakout room. Where are you? There you are. All right, I'll open that breakout room. Okay, so Mr. Jeffords, you might need to use the mouse to click on join, all right? All right, I have someone on a device. The screen just says SS5424G. I'm going to send a request to unmute and start your video, please. Ms. Dunn, what are you appearing on today?
Good morning, Your Honor. I am here on the People versus Ashley Cousino. We have an adjourned
Okay.
pretrial.
Okay, give me just a moment. So,
No worries.
ma'am, with the headphones, you just unmute. What is your name, please? All right. All right, so I'm going to ask you to unmute. All right, can you say your name? Because I don't think we can hear you. Okay, we cannot hear you. So why don't you call back in? Or try a different way to connect your audio. All right, let me get Ms. Cousino in. Okay. All right, Ms. Dunn. I'll let Ms. Cousino in. She's in. And okay. All right.
Oh, I'm
This
sorry.
is
I'm sorry. Mr. Draper is also here with me. I believe he's still in your waiting room. He's my co-counsel.
You just tell him I didn't think it was as important as you.
No worries.
It was a joke.
I understand.
All right, this is in the matter of the people of the state of Michigan versus Ashley Marie Josephine Cousino, file number 22-21022FH. I have Isaac Sneed appearing on behalf of the people. I have David R. Draper, P43750, and Celeste Dunn, P61819, appearing on behalf of Ms. Cousino. This is a time set for a pre-trial in this matter. So, Ms. Dunn, how would you like to proceed?
Your Honor, we do have an outstanding issue. The adjourned pretrial order, and when we were here in court last time for the original pretrial, the medical records of the alleged victim were ordered. All I've received is victim records, alleged victim records from basically the initial treatment. That is insufficient, Your Honor. My client is charged, or our client is charged with a felony pursuant to the Dangerous Animal Act. And that statutory threshold is akin to the no fault.
All right, so hold on a second. So I've got 100 cases this morning and not any time to argue a motion. So if you have a motion that needs to be filed, go ahead and file it. If you have outstanding discovery, have you communicated with Mr. Sneed?
I have, Your Honor. I communicate with Mr. Banetta, who seems to be the lead counsel on the case. And he said all they had was the original documents, and that's insufficient for us to properly defend the client.
Have you requested through discovery the documents from whoever else is necessary? I don't know. So you can file a motion, you can do a motion to quash, you can do a prelim, but I don't do these oral motions on the record.
Excellent.
Understood.
Thank you, Your Honor.
Then we'll file that.
Okay, so I'm going to give you another date for a pretrial. And do you want a date for a motion, or do you just want the pretrial date and then you can get a date for motion when you call?
I think we could have a motion date, Your Honor, if that's okay.
All right, I'm looking at April 19th at 10:30 in the morning.
Very good.
And then I'll set a pretrial with that. So April 19th at 10:30 for a pretrial conference and motion. And I set it at 10:30 because that way I'm done with my pretrial and arraignment docket, because I have about 25 cases I pushed through at 8:15. So you can do this stip in order to adjourn the pretrial. Mr. Sneed, can they sign your name with permission on the stip in order to adjourn the pretrial?
Yes, please, Your Honor.
And then you can just do the notice of hearing for the motion with the motion. All right.
Excellent. Thank you, Your Honor.
All right. All right. Excellent. So we'll see you back on that day, and that'll be via Zoom. Yes.
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 Okay.
Thank you.
All right. Great. Thank you all.
Thank you, Your Honor.
All right, Ms. Van Duzen and Mr. Jeffords. So we're back with Mr. Jeffords. Ms. Van Duzen, how do you wish to proceed with Mr. Jeffords today?
Your Honor, he is going to plead, but Mr. Fleming has to get an amended complaint.
Okay, I am fine with taking the plea without receiving the amended complaint, and Mr. Fleming will file it by the end of the day. Is that all right with you, Ms. Van Duzen?
It is, Your Honor.
All right, so if I could just, because there are multiple files, I have on file number 18, that's a bot. Okay, so he's got a bot file. Is he going to plead on the bot file?
Yes, Your Honor. My understanding. is through Chris, that we're gonna try to get that to go away and can I talk to Mr. Jones real quick? I've got a little conversation going with him.
You want to break out room with Mr. Jones?
Yes, please.
Okay, Mr. Jones, is that all right?
Yep.
Okay. All right, so I'm gonna sign Miss Van Duzen and Mr. Jones. Okay, so Mr. Jeffords, just hang out for a moment. All right. Signal and defense attorney. Okay. What is your name?
Sir. O.B. Ronald Wood.
Wood? All right, Mr. Murphy, let's see, you probably have today, Miss Van Duzen today, right? Okay, so when we're done with Mr. Jeffords, we'll take care of you, okay? So you can go on your way. All right, I have.
Yeah.
Hi, I have a gentleman on an iPhone. What is your name, please?
Deontay Sullivan.
All right, sir, hold on one second. You are, and Mr. Malaro is your attorney, and he is next door for a hearing. So I'm gonna change your screen name and I'm gonna pop you in the waiting room, okay?
Okay.
Thank you, Mr. Sullivan. All right, we're back with Mr. Jeffords, Miss Van Duzen. Are you ready to proceed?
We need a breakout session with you, Your Honor.
With me?
Yeah.
Okay. Okay. So I am gonna open up a big breakout room. And hold on. I'm gonna close this room. I'm gonna add Miss Adams to the breakout room. And then do we need the prosecutor too?
This is regarding.
You can bring them along if you want.
Yeah,
but
it's regarding probation.
Oh, so it'd be Mr. Sneed, right?
Fleming.
That'd be my case, Judge.
Oh, Mr. Fleming. Okay, Chris Jones. I'm gonna add Becky Adams. And then I am going to open that room and go back in Becky's office.
Mr. Jeffords,
Yes.
real quick, you're gonna plead guilty to the violation of probation. I just talked to the judge, and at sentencing, she'll just charge you from your probation with Mr. Jones.
Got it.
Okay,
Thank you.
yep.
Quick question. The charge that the charge that I'm pleading to, will it go down as, it won't go down as,
It's just a misdemeanor.
okay, cool.
Mhm.
Cute. Thank you.
All right.
All right, so we are back on the record with Mr. Jeffords. Okay. All right, so Ms. Van Dusen, I've had an opportunity to meet with you, Mr. Jones, and Mr. Fleming. So it's my understanding that on file number 18-19058 FH, Mr. Jeffords is going to plead guilty to the violation of probation. And we will set that for sentencing. Do you need to talk to your client again?
No, Your Honor, but I think we need to put the competency report on record, though. And the
Yeah,
criminal
we do.
responsibility.
Yep, I do have that. Okay. So on file number 21-20628 FH, the court has received an opinion on competency to stand trial that is dated December 21 of 2022. Did you receive that, Mr. Fleming?
We have, Judge.
Have you received that, Ms. Van Dusen?
Yes, Your Honor, and we have no objection to the court reading it into file.
Okay, I will tell you that I have not received a criminal responsibility.
I did, Your Honor.
I didn't. Did it find him criminally responsible?
No.
Did you receive that, Mr. Fleming?
I just have one from the same date as far as criminal responsibility goes that states that he refused to complete the criminal responsibility portion.
And yes, that's what it states. And it further states that I gave a call to the person, Mr. Knighton, PhD, and he states that he believes that he would be found criminally responsible, so that it really did not need to be completed.
Okay. All right. So on December 21st of 2022, from the State of Michigan Department of Health and Human Services Center for Forensic Psychiatry. Oh, I do see that. It was one page. I'm sorry. We received a report by J. Knighton, PhD, licensed psychologist, consulting forensic examiner, which found in the findings that Mr. Jeffords' mental condition during the forensic interview was profane, uncooperated, and agitated. His interview was discontinued due to continuous attempts to provoke, berate, demean, and control the interview. His clinical presentation is grossly consistent with collateral data describing him as argumentative, provocative, and anti-authority. Neither the collateral data nor his clinical presentation warranted concern about genuine neurological deficits, though thought dysfunction, nor a significantly depressed affect, which may undermine his functional capacities. Conversely, Mr. Jeffords' presentation impressed as volitional and consistent with a maladaptive interpersonal style, which persists despite the status of the observer, judge, consequences, and is generally uncharacteristic of a mood or thought disorder. Thus, the collateral data suggests his conduct during the interview was volitional and unrelated to a mental condition which could impede his adjudicative capacities. Mr. Jeffords refused to discuss psycho-legal concepts, including plea options, key courtroom personnel, court procedures, or potential legal strategies. However, the absence of an impeding mental condition, recurrent exposure to the legal system, estimated cognitive functioning, and prior forensic examination suggest he has capacity to understand and apply psycholegal constructs. The data further suggests he has a recent history of understanding and applying legal constructs via rational decision-making. Thus, the aggregate data suggests he has the capacity to comport his conduct, rationally assist his attorney, and make rational legal decisions if and when he chooses. The collateral data warrants concern about appropriate behavior during legal proceedings. However, there is no substantive clinical data suggesting he lacks the capacity to comport. Therefore, it is this evaluator's opinion Mr. Jeffords did not have a mental condition impeding his capacity to understand the nature and object of the proceedings against him, or to rationally assist in his defense during the forensic interview. The undersigned respects the ultimate decision in this matter depends on a judicial determination, though it is this examiner's opinion that Mr. Jeffords is competent to proceed with his legal case. And then there is, a one-page document dated December 21 of 22 that states that Mr. Jeffords refused to complete the forensic interview as intended, and they're unable to offer an opinion within the bounds of reasonable medical certainty without active or appropriate participation, and signed by the same J. Knighton, PhD, licensed psychologist, consulting forensic. I just handed that to Sue so she can see what I read from. All right, so the court will make the finding that he is competent to stand trial. Ms. Adams, I do show we have no fingerprints, but he's in the jail. So I'm assuming they can get that done. Ms. Van Dusen, on file number 22-20628FH, what will he be pleading to on that file?
It'd be MDOP 200 to 1,000. With
so it'd be an added count 2.
Yep.
MDOP 200 to 1,000, which carries a 1-year maximum penalty.
With a killabrew to no further jail.
No further upfront jail?
No further jail, correct, Your Honor.
Okay, so at the time of sentencing, he'll be released?
Upfront. I thought he would be released today, Your Honor.
Mr. Fleming?
That's fine, Judge.
Okay, so we'll give him a PR bond today on that file. All right, and then on the violation of probation, I'll arraign him on that. So, Mr. Jeffords, let me get back to the front of my script. So can you raise your right hand for me, Mr. Jeffords? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Mr. Jeffords, can you state your full name for the record?
Jonathan Michael Jeffords.
Thank you. Now, Mr. Jeffords, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention on file number 21-20628FH to plead guilty to count 2, malicious destruction of property, 200 to 1,000, which carries a maximum penalty of up to 1 year in jail and restitution, but with the agreement that you would receive a PR bond from jail today? So is it your intention to plead guilty to that count?
I thought there was no jail time at all. I don't understand.
Well, you're in jail now, so you would be released from jail today.
Right.
So there would be no further jail on this unless you violate your probation.
Oh, okay.
So you would plead to the misdemeanor.
And I would
agree, I
would do restitution and that type of thing.
Right, and fines and costs.
Okay,
but you would be placed on probation, so there'll be no further jail now. But just to warn you, down the road, you violated probation, there could be jail, but there's no jail now.
okay, yeah, yes, Your Honor. Yes.
Okay. Now, you also have a violation of probation, which we're gonna address once we get the plea on this, okay?
Okay, and the agreement is to terminate probation once,
The agreement is that at the time of sentencing on the violation of probation, I will terminate your probation with Mr. Jones.
yes, Your Honor.
Okay, so on that file number 18-19058FH, the allegation against you for a violation of probation is that you were arrested on August 25th of 2021 by the Adrian Police Department for malicious destruction of property. So do you understand that's the violation against you?
Yes, Your Honor.
And are you going to plead guilty to that violation of probation? And that's the one where there's the agreement, your probation would be revoked and terminated.
Yes, Your Honor.
All right, now, even the penalty on that offense could have been up to 2 years in prison or jail, but you understand your probation will be revoked, right?
Yes, Your Honor.
Okay. All right, now, are you satisfied with Ms. Van Duzen and the advice that she's given you?
Yes, Your Honor. Absolutely.
All right, good. And I explained to you on the new charge, the maximum penalty could be up to 1 year in jail, but you'll be released from jail today. Do you understand that?
Yes, Your Honor.
So other than what was placed on the record today, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other sentence with the court. Is that correct, Mr. Fleming?
That's correct, Judge.
Ms. Van Duzen?
That's correct, Your Honor.
And Mr. Jeffords, is that correct as well?
Yes.
All right. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
I understand.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Yes.
If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
I do not.
All right, so Mr. Jeffords, I'm going to start with your new file on file number 21-20628FH. Mr. Jeffords, how do you wish to plead to the charge that on or about August 25th of 2021 in the city of Adrian in the county of Lenawee, that you did commit the offense of malicious destruction of personal property, 200 with a value of 200 or more, but less than 1,000? Guilty or not guilty?
Guilty.
Okay, and then Mr. Jeffords, on the violation of probation file 18-19058FH, how do you wish to plead to the allegation that you violated the terms of your probation by being arrested on August 25th of 2021 and charged with malicious destruction of property? Guilty or not guilty?
Guilty.
Okay, very good. All right, and has anyone made any threats or promises to you to induce you to plead guilty to these charges?
No.
Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
I understand.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Fleming?
No, Judge.
Ms. Van Duzen?
No, Your Honor.
Other than what was placed on the record, Mr. Jeffords, has your attorney promised you any other particular sentence or estimate of what your sentence will be?
No.
All right, is it your own choice to plead guilty?
Yes.
All right, so Mr. Jeffords, I'm going to start with your new file on file number 21-20628FH. So Mr. Jeffords, would you agree that on August 25th of 2021, you were in the city of Adrian in the county of Lenawee?
Yes.
And at that time, did you damage a vehicle that belonged to someone with the initials MS?
Yes.
Okay, what did you do with it? Did you kick it? Did you punch it? What did you do to the car to hurt it?
Yeah, I'm not really totally sure. Contrary to the report, I do have mental issues, so yeah.
I understand that. Would Ms. Van Duzen, do you wish to ask him a question?
Yes, did you pick up a statute and throw it at the car?
I honestly, I wouldn't remember.
Can we change his plea to a no contest, Mr. Fleming?
No objection to that, Judge.
All right, so Mr. Jeffords, because of your lack of memory, would you like to enter a no contest plea and have Ms. Van Duzen place on the record what happened that day?
Yes.
Okay, Ms. Van Duzen, would you like to place a factual basis on the record?
Yes, Your Honor, give me 2 seconds.
Not a problem.
Okay. Okay, on August 25th, 2021, Mr. Jeffords was on Frank Street in South Center in Lenawee County, city of Adrian. And a vehicle that was driving by, Mr. Jeffords picked the statute up and threw it at the window of that car. For no reason at all. It damaged the window to a vehicle that was not his and owned by a complainant.
And the damage to the vehicle was between $200 to $1,000 to repair.
Yes, Your Honor.
Mr. Fleming, anything you'd like to add?
That vehicle was owned by Michael Summer as well, and people are satisfied.
All right, so based on the facts placed on the record and from the information contained in the police report as read by Ms. Van Duzen, the court does find beyond a reasonable doubt that on or about August 25th of 2021 in the city of Adrian in the county of Lenawee, that Mr. Jeffords did throw a statue at a vehicle belonging to an individual with the initials of MS, damaging said vehicle's windshield, and the amount of destruction was between $200 to $1,000. Therefore, the court does accept the no contest plea. And then, Mr. Jeffords, I will use that for the basis of accepting your violation of probation plea as well. All right?
Yes, Your Honor, thank you.
All right, Mr. Fleming, has the court complied with MCR 6.302 B, C, and D?
You have. Thank you, Judge.
Ms. Van Duzen?
Yes, Your Honor.
All right, I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights, and he does have competent counsel. I'm going to refer, all right, so here's Mr. Jeffords, where I'm going to need some help from you. So I'm going to set this for sentencing on April 6th at 8:15 in the morning. Are you available that day, Ms. Van Duzen?
Yes, Your Honor.
And your paperwork, when you get out of jail, is gonna have that date on it. You understand?
Yes, Your Honor.
All right, and you're gonna come in person for sentencing, right?
Yes, Your Honor.
All right, now, Mr. Jeffords, where, you're gonna get released from jail today. Where are you gonna go live?
I am going to live at the Share the Warmth. I'm going to attempt there, as we spoke before, me and Miss Van Duzen. They're very good at getting people in there. So I'm very confident that I will have a place to stay.
Okay, so Mr. Jeffords, a couple things. You have to do what I tell you to do here in a minute, and if you don't, I'm gonna issue a bench warrant for you and you'll end up back in jail. Do you understand?
Yes.
So I'm gonna release you from jail today, but you are going to have to report to see Mr. Jones next Tuesday, Mr. Jones. When does he report to see you?
Yeah, that's fine, Judge. Next Tuesday, 8 a.m.
Okay, so this Thursday, tomorrow morning, you have to go to district court probation on the first floor between 8 and 10 a.m. Do you understand that?
I heard 8 and 10 a.m. The date again? I'm sorry.
Tomorrow, just tomorrow.
Tomorrow. Okay,
Thursday.
yeah.
And that's district court probation, which will be doing the report for the misdemeanor you pled to today, all right? So tomorrow morning, you have to go to district court probation between 8 and 10 a.m. and check in. Next Tuesday morning, you need to report to Mr. Jones, all right? Like you normally do. And then your sentencing on your paperwork will show April 6th at 8:15. So you need to be back here for that sentencing, all right?
Yes.
Now, before we had to chase you around. I don't want to have to chase you around again, okay?
I will make myself available, Your Honor.
All right, and then you need to stay in contact with Miss Van Duzen also, because she'll review your reports with you at some point, okay?
Yes.
All right, so we'll see you back here April 6th at 8:15 in the morning. That can be Zoom or if you'd like, Mr. Jeffords, or in person. So I know that you may not have a phone, so you're more than welcome to show up here in person as well, okay?
Thank you. Yes, in person.
All right, we'll see you then, Mr. Jeffords. You have a good day.
Thank you.
Judge, just to make sure there was no bond on my warrant, but you're changing that to PR, correct?
Yes.
Just for the record purposes. All right, thank you.
Yeah, so Ms. Adams, that'll be a PR bond on both of us. All right. You're all set, Mr. Jeffords.
Thank you. Have a great day.
Thank you. You too. All right, Ms. Van Duzen, I have in my courtroom, I have Mr. Wood. So
I'm gonna come over, Your Honor, if he's there.
okay, so she's gonna come over to talk to you, all right? Okay, so Mr. Decker-Markosian, you have maybe somewhere here. You have Shelby Smith, and let me see if she's in my waiting room. Not really.
Judge,
Mr. Malaro, you have William Dodson, right?
I don't think so, Judge. It's Miss Underwood's blessing today.
Let's see who this person is. All right, so Michael Decker-Markosian, Ms. Smith is in bench warrant status.
so, Your Honor, Mr. Smith is in an Ohio prison.
Oh, hold on. In the matter of the people of the state of Michigan versus Shelby Vernon Smith, file number 22-21114FH. I have Michael Decker-Markosian appearing on behalf of Mr. Smith and Isaac Sneed appearing on behalf of the people. That's right. So Shelby Smith is in Ohio prison. Is that correct?
It is correct, yes.
And I issued a warrant just in the event he gets out. We can pick him up.
That's true. We had coordinated with your staff about trying to get him on to Zoom. We were able to do it in district court. I don't know if what the status is with that as far as getting him on.
Ms. Adams?
Yes, I sent you a message about that regarding the last hearing.
Okay. All right, so it looks like the prosecutor's office did not send the Ohio correctional request for today. She said, I think there was some confusion, Mr. Sneed, because of the district court and the circuit court. So your office did not send the one for today. They did, for whatever reason, send the district court one. So we'll need to adjourn this out and have Ms. Cates do the request for circuit court. All right, Mr. Sneed? You're muted.
Yes, understood, Your Honor. I'm just looking at my prior notes, and I think there was an issue with the writ since he was out of state, but I'll follow up with Ms. Cates.
Yeah, they got him for district court, just not up here. So Mr. Daggermer goes in. How about this? I'm going to need some time to do that. So I'm going to set this for March 15 at 8:30 in the morning. 8:30 in the morning for another pretrial. You can do the step in order to adjourn, and Mr. Sneed, your office can do the writ. All right.
Yes, thank you.
And I think Mr. Daggermer goes in. That's all I have with you this morning.
I think there was a pickup for Aaron Carr.
Maybe, but I haven't even looked at pickups yet.
Okay.
So I have all my other stuff to do. So Ms. Carr will probably be the last pickup. If you want to go do the rest of your morning and pop back in later.
I'll
or
do
we'll
that.
text you.
Okay.
Okay.
I'll do that. Thanks, Judge.
Okay, so Sierra, I have a phone that says Sierra. Can you unmute your device?
This is Christina Edmonds.
Oh, okay.
Okay.
All right. It's okay. So Ms. Edmonds. All right. So I'll find you. All right, so Mr. Milaro, you still with me?
Always, Judge.
Always. All right, so Mr. Milaro, let me find my criminal pretrial schedule. This is in the matter of the people of the state of Michigan versus Christina Edmonds, file number 21-20320FH. This is the date and time set for a pretrial conference in this matter. Today was also the deadline to file jury instructions, or will be at 4:30. The deadline to file jury instructions of voir dire questions, as well as any motions. We are set for jury trial on February 22nd, just here in a few weeks. It looks like there was a plea offer to a 4th degree, which carries, what is that, a 2-year, Mr. Sneed or Mr. Milaro?
Yeah, I don't know.
4th degree child abuse?
Might be.
I believe it's a 2-year, Judge.
I don't have an, okay. And then she, just for the record, she's charged in count 1 with a 10-year felony. So the maximum, if she were convicted at trial, she would be looking at life in prison. So, all right. So Mr. Milaro, how do you wish to proceed today?
Your Honor, Ms. Edmonds in the past has always maintained that she would not be entertaining any plea offers. So I would just be confirming our trial date for February 22nd.
Okay, so, Mr. Sneed and Mr. Malaro, by the end of today, I need your jury instructions and any case-specific, voir dire questions. Ms. Edmonds, we'll see you back here on February 22nd at 10:30 in the morning for jury trial. And it's scheduled for 2 days.
Okay.
And we'll see you back on that day. Thank you.
Okay, thank you. You guys have a blessed day.
You too. Okay, so she's in the hall. And sir, what is your name? All right. Mr. Malaro. Mr. Malaro, I have Mr. Maureen here today and
Mr. Who?
Straight. Ray Michael Maureen, Morin. It's file number 20-19788FH. I'll give you a moment to get that file. He was kind enough, and I do appreciate, he was released from prison in Ohio, yes, or jail or prison. And he was told to appear this morning, and he did.
Who? What?
He's
How do you
here.
spell his last name?
Morin. He pronounces it Maureen.
Oh, Morin. Yeah. Okay.
Not Maureen, Maureen.
Michael.
And-
Michael, right?
Yep. So he is here. It's a probation violation, right?
Oh, okay. That.
Oh,
yeah,
you know what?
okay.
This is a probation violation. Okay, so who's the PO on this? Who is your
Is this the
probation
weapon?
officer?
Is this the weapons case, Judge?
No, I thought everything was closed here, and then they said you need to go report.
Okay, hold on, let's see here. Let's see what's going on. I'm sorry, Mr. Malone. This is like a really old file for a so who's charged? Not okay, so I have request and warrant for probation violation. Miss Holly, this is a 20 file. How long have you been in custody in Ohio?
A couple days.
Only a couple days. Okay. I'm guilty. Okay. Not on the docket, so it's a pickup, file number 20-19788FH. Let's see. Under judgment. So you were only in custody in Ohio for like a couple days?
Yes, ma'am.
Okay.
And then that's when I was told about, I have this, and then I had to pay a bunch of money, they said, so I paid a bunch of money, and they said that I didn't have no more court cases or nothing on the docket, so.
So did you post your bond on this file?
Yes, ma'am.
Okay. Mr. Moore, is it
Yes.
possible for you to look up the paperwork on this and see what his balance owed is?
Well,
And
we
if
can do that.
it's
I do know because we put that warrant together for a violation of probation regarding an assault down in Toledo that he pled guilty to, and that's what that as well as what is owed. But I can look that up.
I would just like to know, it looks like he posted the $1,658. I'd like to know if he's paid in full now.
Okay, give me a minute. Thank you.
So hang on just for a moment, Mr. Maureen.
Judge, I handled the original file, so I'll be more than happy to do the VOP if we need to.
All right, let's see what happened with the money he posted, so. All right, so Mr. Malaro, I have in my waiting room. Don't go away. Lisa Hannibal, Bridget Reinhardt, somebody named Tammy. Deontay Sullivan, no, he's Mr. Is
No,
Deontay
he's
Sullivan
mine.
yours?
Those are all mine so far.
Okay, let me bring in Mr. Sullivan because he's been here. All right. Hi, Tammy, what is your name, please?
Tammy Bannon.
Bannon? Okay, I'm gonna put you in the waiting room and I'll bring you in just a minute. All right, this is in the matter of the people of the state of Michigan versus Deontay Sullivan, file number 2019-19746FH. This is the date and time set for a pretrial in this matter. It's a final pretrial. Mr. Sullivan is set for jury trial on February 22nd at 10:30 a.m. Mr. Sullivan is charged with a 10-year assault with intent. He has a third offense notice. Let's see. There's an old plea offer in this file, but is there anything more recent?
I don't know, Judge. Would it be possible for me, Mr. Fleming and Mr. Sullivan to do a joint breakout room?
You want to meet with Mr. Fleming first and then the three of you?
I think the three of us, maybe we could get a resolution. But I would like Mr. Sullivan to be part of that.
Okay. All right. So here we go. All right. So Mr. Sullivan, I'm going to open up a breakout room. And I'm going to add you and Mr. Malaro and Mr. Fleming. And there you go. Go ahead and click on join that breakout room. All right, Ms. Bannon, this is in the matter of Tammy Bannon versus Anthony Haybecker, file number 21-49015FH. I have Isaac Sneed appearing on behalf of the prosecutor's office. This is the date and time that was scheduled for a PPO hearing. Mr. Haybecker has not appeared. Mr. Haybecker does continuously leave messages. Mr. Haybecker was also called about today and he was notified to appear. He's failed to do so. They issue a bench warrant for his arrest and they will set bond in the amount of $25,000. He was also ordered to appear in person. And that would be cash. All right, Ms. Bannon, thank you.
Okay, thank you.
Where did you, Mr. Maureen?
Yes, ma'am.
Where did you pay the money at?
Downstairs?
Pay money here?
Yeah, it was all done online on the computer. I went and retrieved all of my records and it says everything's been closed.
Okay, Mr. Moore, he has documents with him. I'm gonna send him over to the office across the hall. He says he has some paperwork.
Okay.
And someone over there can look at it.
Yeah, I just got done speaking with Deb and she said that it shows that money was not posted. So that would be something, if he has a receipt or showing it was posted, that she can go show, that he can show that to her.
Okay, so,
It was all done online through the computer.
okay, so I want you to go check in at the front desk of the probation department. Mr. Moore, can you let some?
The clerk, have him goes to the clerks with that. So go down to the clerk's office and ask for Deb.
So go down at the end of the hall at the clerk's office and ask for Deb, all right?
Okay, yes.
All right, so Mr. Sneed, Ms. Van Dusen is here with Mr. Wood. This is in the matter of the people of the state of Michigan versus Ronald J. Wood. File number 22-20782FH. I have Dawn Van Dusen appearing on behalf of Mr. Wood, and I have Isaac Sneed appearing on behalf of the people. I have received an amended felony information adding a count 2. Operating while intoxicated, second offense, which is a 1-year misdemeanor. And then I also have the plea agreement form in my file. So I appreciate those, I do. So Ms. Van Dusen, how would you like to proceed today with Mr. Wood?
But the offer also is a Killebrew to no upfront jail for it also. But I think Mr. Wood should be the one to decide. I told him what the plea offer was. And I also told him that there would also be trial on Tuesday if he does not accept this.
Okay.
So he has that option to tell us what he wants to do.
So Mr. Wood, you are charged with operating while intoxicated, third offense notice. It does carry a maximum penalty of anywhere from 1 to 5 years in prison or probation with 30 days to 1 year in jail with a requirement of 48 hours to be served consecutively. There's $500 to $5,000 fine and reimbursement and cost of prosecution. You do not have any prior felonies, so the maximum penalty would remain up to 5 years in prison. The plea offer that's being offered is a misdemeanor. And the misdemeanor carries up to 1 year in jail. And there's a Killebrew to no upfront jail. Do you understand that?
Sure.
Okay, and just for transparency, so that you can, make that decision, you are set for trial, the 14th.
Tuesday.
Tuesday, and that trial will proceed. Understand if you are convicted, you will be remanded to custody for the jail for 6 weeks pending sentence. Do you understand that?
Sure.
I understand it's really hard to be on that side and having to make these decisions because you got to think about yourself and your family. If you need a couple moments to think about it, you're more than welcome to go have a seat or make a call. I'm here all morning, or you can continue it to trial or take the plea.
So I'll take the plea.
Okay, so Mr. Wood, raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
Okay, can you state your full name for the record?
Ronald J. Wood.
All right, so Mr. Wood, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 2, operating while intoxicated, second offense, which carries a maximum penalty of up to 1 year in jail?
Yes, sure.
Okay, and Mr. Moore, are you covering? Okay, because I don't see Mr. Jones. All right, so sir, other than the Killebrew agreement, neither the prosecutor, the defendant, nor anyone on the defense behalf has discussed a possible sentence with the court, and that would be regarding fines, costs, for your service. Is that correct, Mr. Sneed?
Yes, it is, Your Honor.
And Ms. Van Dusen?
That's correct, Your Honor.
And sir, is that correct as far as you're aware?
Yes, sure.
Okay. And if a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that?
Yes, sure.
All right. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that?
Right. Yes.
Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that are given to you? All right. So Mr. Wood, how do you wish to plead to the charge that on or about October 14th of 2021, Mr. Sneed, I don't have city, township, felony information. Does the old one have one? Nope.
I'm looking that up right now. Unless Mr. Wood remembers where he was.
It's West Carlton Road, but I don't know where that is. Like, is that Adrian?
Hudson.
Is that Hudson? Okay, so, were you in the county of Lenawee in Hudson, Michigan?
Yes.
All right, and, did you commit the offense of operating while intoxicated, second offense?
Yes.
Okay, and do you wish to plead guilty?
Yes.
And I'm sorry, I completely went around that the wrong way. How do you plead to that charge?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to this charge? Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that?
Yes.
Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Steen?
No, Your Honor.
Ms. Van Duzen?
No, Your Honor.
All right. Has your attorney promised you any particular sentence or estimated what your sentence will be other than the Killebrew and no upfront jail? Okay. And is it your own choice to plead guilty?
Yes.
All right. So, Mr. Wood, on October 14th of 2021, were you driving on West Carlton Road?
Yes.
And would you agree that is in Lenawee County?
Yes.
And it was in Hudson?
Yes, sure.
All right. And at that time, had you consumed alcohol?
Yes, sure.
And would you agree that your alcohol content was above 0.08?
Yes, sure.
All right. Did you have a PBD done?
They drew blood.
They drew blood, and what was that blood draw?
I don't remember.
Ms. Van Duzen?
0.008.
0.008?
I don't remember.
Mr. Flemstein, do you know what the blood draw results were?
I'm looking that up right now.
Thank you.
I just don't have my computer open, so
I know, it's okay.
0.088.
0.088. So would you agree your blood alcohol content was 0.088?
Yes, sure.
And would you agree that is above the legal limit?
Yes, sure.
Okay. And you were driving a motor vehicle, correct? Are you satisfied, Mr. Steen?
Yes, Your Honor. Thank you.
Okay, has the court complied? Oh, well, wait, I'm sorry, I misspoke. Now, you have a previous conviction on April 18th of 2012 in Midland County, Michigan. Is that correct?
Right.
Okay. And you also, okay. All right, so that satisfies the second offense. Has the court complied with MCR 6.302 B, C, and D, Mr. Steen?
Yes, Your Honor.
Ms. Van Duzen?
Yes, Your Honor.
All right, I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights, and he does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew plea. I'm going to refer this matter to the probation department for a pre-sentence investigation. So, Mr. Wood, this will actually be probation through district court, even though I'm a circuit court judge. All right. Do you still live in Farwell?
No, I live in Jackson.
You live in Jackson?
My record should have been updated. I live at 6314 Wells Road, WELLS Road, Jackson.
Okay.
4920.
Okay. So, Mr. Wood, you might, so I usually would tell you to report to the district corporation tomorrow morning between 8 and 10. But if you want to stop by there today, they might give you the information you need so you don't have to drive back in tomorrow. Okay. And I'm going to set sentencing in this matter for same day I sent your other one. Because there is a Killebrew and no upfront jail, Ms. Van Duzen, any objection, or do you want to do it via Zoom?
Yes, please, Your Honor.
All right, so Mr. Wood, you have the right to be present in person for sentencing, and some people like to because they don't like using Zoom. Or you have the right to Zoom in for sentencing. So because there's no upfront jail, I'll allow you to Zoom. So would you like to appear via Zoom?
Yes, Your Honor.
Okay, so I'm going to set this matter, and Ms. Adams, could I get a sentencing notice for Mr. Wood because he's here? So I am going to set this for sentencing on April 6th at 8:15 in the morning. And that'll be via Zoom. And we will get you a notice. So, like I said, stop by down there today. Maybe they'll give you your information today. Otherwise, you'll have to drive back in tomorrow morning between 8 and 10. Make sure you meet with them and take their phone calls, do whatever you need to comply with that. They'll do a pre-sentence report. We'll send a copy to Ms. Van Duzen. She'll get a hold of you and review that with you. And then we'll appear for sentencing on April 6th at 8:15 in the morning via Zoom. Your bonds continued. Anything else we need to address?
No, Your Honor.
Okay, so Mr. Wood, just have a seat right behind you and we'll get you that notice, okay? Ms. Van Duzen, thank you. Are you going back to your office?
I have one other one is
So,
individual.
Mr. Maureen, but I have Lisa Hannibal, Bridget Reinhardt, and William Dodson. Do you have Kyle Roberts?
No.
And I don't think any of you else. Let's look who else you have.
I have Kyle Roberts, Your Honor.
Mr. Wood. I don't think. All right, Milton Rembert.
Yes, Milton.
He's not in jail. Let's see what this is. I don't have him in my waiting room. So he usually shows me now. Maybe. All right, I have a gentleman wearing a hat. So you want to take your hat off? All right, thank you. Even though we're not in court, we're kind of in court. So what is your name, please?
It's William Dodson. I was on another one. You had me on hold.
I know, you're next though, so just hang out.
Okay,
So
I
if
was
you want to go
making
back to
sure
your
you got
office and try to call Mr. Rembert.
I will. Thank you.
Okay. All right, so, I got you in 2 places. All right, so, who is your attorney, Mr. Dodson?
Underwood.
Okay, I still do not have Miss Underwood. And the reason I don't have her is she went to Judge Olsavers first. So if you want to call back in 15 minutes.
All right, I can do that.
Okay, thank you.
Thank you.
Judge,
Okay.
Judge, regarding
Yes.
Rembert,
Mr. Maureen? Oh, what'd you say, Rembert, Mr. Moore?
so we have a warrant for him right now. He's aware of it. I was trying to get him. He said he'd come in this morning, turn himself in, but he's obviously has not done that yet. And I don't.
Okay, all right, so I'll call it when Miss Van Dusen logs back in. All right, so Mr. Maureen, you talked to Deb over there?
Yes, there was a discrepancy. My money was supposed to be for circuit, they ended up going to district. They said that they gotta pay in person, or I used my money from savings to obviously for circuit, but it went to district.
So somehow he paid the money and it got applied to district court and not here. So Miss Adams, could you call and talk to her and find out if it was improperly applied? Because if it was, we can get it back.
I'm sorry, Judge, who am I calling?
Deb over in the clerk's office.
Oh.
All right, so just hang tight.
Because I had a hold when I was in custody.
I know.
That's how I got lifted.
Okay, just hold on. All right, so Mr. Malaro with Mr. Sullivan.
Yes, Judge.
Yes, Judge.
All right, so we're back on the record with Mr. Sullivan. So Mr. Malaro, how do you wish to proceed with Mr. Sullivan?
Your Honor, I believe we're going to enter a no contest plea to an amended count 2 felonious assault, a 4-year felony. And there's going to be a Killebrew agreement to no immediate jail and or prison. And that, I believe, is our agreement.
All right, is that correct, Mr. Plum?
That is correct, Judge.
All right,
And,
so Mr.
Of course, no supplements or habituals.
Okay, so Mr. Sullivan, you want to raise your right hand
Yes,
so I can see it? Okay, do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
yes, I do.
All right, so now that you're under oath, can you state your full name for the record?
My name is Deontay Sullivan.
All right, so Mr. Sullivan, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest to count 2, which will be a felonious assault, which carries a maximum penalty of up to 4 years in prison, with a Killebrew agreement that there would be no upfront jail? So is it your an intention to plead guilty to that count?
Yes,
Or I'm sorry, no contest. You're gonna plead no contest, correct?
yes, ma'am.
Okay. Now, are you satisfied with Mr. Milaro and the advice that he has given you?
Yes,
Okay. Other than the Killebrew agreement for no upfront jail, neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed any other possible sentence with the court regarding fines, costs, probation terms. Is that correct, Mr. Milaro?
That is correct, Judge.
And Mr. Fleming?
That's correct, Judge.
And Mr. Sullivan, is that correct as far as you're aware?
yes,
All right, if a guilty plea is, or if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at a trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial, not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at trial? Do you understand that, Mr. Sullivan?
yes, ma'am.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right? Do you understand that, Mr. Sullivan?
Can you repeat that last part?
Yep. Do you understand that any appeal from your conviction and sentence pursuant to the plea would be by application for leave to appeal and not by right? So if you had been convicted at trial, you would have an automatic right to an appeal, but because you're entering a plea, you would have to file an application to appeal. Do you understand that?
Yes,
Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you?
no, I don't.
All right, so when I ask this question, sir, my understanding is you're going to plead no contest, so you would have to say no contest, all right, if that's what you want to do. So, Mr. Sullivan, how do you wish to plead to the charge that on or about October 30th of 2019 in the city of Adrian in the county of Lenawee, that you did commit the offense under count 2 of felonious assault?
No
You say
contest.
no contest, Mr. Sullivan.
He said that, good. He's got a delay, so he's like a couple seconds behind us. All right. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No,
Okay. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea. I'm sorry, I had to yawn. Okay. Let me say that again. Do you understand if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? You understand that?
No contest.
Right. I'm just saying that.
Oh, yes,
All
yes,
right.
yes, yes.
Yep. So you're giving up any claim that there were any promises or threats that were made that we're not aware of. Do you understand that?
Yes.
Okay. Is the prosecutor or defense counsel aware of any promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Malaro
No, Your Honor.
and Mr. Fleming.
No, Judge, thank you.
All right. So other than the no upfront jail, Mr. Sullivan, in terms of probation, fines, and costs, has your attorney promised you any particular sentence or estimated what that sentence will be?
No.
Okay. Is it your own choice to plead no contest?
Yes.
All right. So who will be placing the factual basis on the record, Mr. Malaro or Mr. Fleming?
I'll do it, Judge.
Okay. So Mr. Fleming or Mr. Malaro?
Yes, Your Honor. Your Honor, we believe that the state would be able to prove beyond a reasonable doubt that on or about October 30th of 2019 in the city of Adrian, County of Illinois, state of Michigan, that Mr. Sullivan did assault a Taylor Vila using a weapon, and that caused her injury.
What was the weapon? Hand? Sandwich?
At the very least, it was a fist. That would have been his weapon. And she did not, the physical contact he inflicted upon Ms. Vila was without her consent.
All right. Any additions, Mr. Fleming?
No additions, Judge.
All right. Based on the facts placed on the record and from the information contained in the police report as read by Mr. Malaro, the court finds beyond a reasonable doubt that on or about October 30th of 2019 in the city of Adrian in the county of Lenawee, that the defendant did commit the offense of felonious assault by assaulting a victim named TV by using his fist as a weapon without her consent, and therefore the court accepts the no contest plea. Mr. Malaro, has the court complied with MCR 6.302 B, C, and D?
I believe it has.
And Mr. Fleming, has the court complied?
Yes, Judge, thank you.
All right. The plea was given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights and he does have competent counsel. The court will honor the Killebrew agreement that was placed on the record. I am going to refer this matter to the probation department for a pre-sentence investigation. Mr. Sullivan, are you living here or are you in Detroit?
Detroit, ma'am.
Okay. All right. So Mr. Sullivan, before you disconnect, I'm going to put you in a breakout room with Mr. Moore, and he's going to give you instructions on how you need to proceed going forward. There'll be a packet you need to fill out. You're going to have to meet with the probation department. They'll prepare a pre-sentence report. We'll provide that to Mr. Malaro. He'll call you. He'll review that with you. And then just be truthful with them about your background. You pled no contest, so obviously you don't have to talk about the offense, but about your background. I'm going to set this for sentencing on April 6th. Are you available that day, Mr. Malaro?
I would expect to be, yes, Judge.
It's a Thursday. Is that okay?
At this point, yes.
Okay, so I'm going to set this for sentencing on April 6th at 8:15 in the morning. Now, Mr. Sullivan, because there's an agreement to no upfront jail, you do have a right to be present in person for sentencing. but because of the agreement, you could appear via Zoom if you would like to appear via Zoom. So how would you like to appear for that sentencing?
Zoom is fine. Zoom, I can do Zoom.
Okay, so Mr. Sullivan, just make sure you comply with the request from MDOC and meet with them. And then we'll see you back on April 6th at 8:15 via Zoom. And Mr. Sullivan, I am going to open a breakout room for you to meet with Mr. Moore, and he'll tell you what you need to do, all right?
Okay, thanks.
All right, thank you, Mr. Sullivan. You should get that invitation to join. Ms.
Thank you,
Van
Judge.
Duzen. Thank you. Ms. Van Duzen, yes.
According to the clerk's office, Mr. Moran only paid on district court, not circuit court.
Yeah, I know. It was supposed to be applied up here. I understand. What do you got?
I'm just reading through my paperwork. They gave me an OR bond on the warrant.
Can you get that? Can I look at that? Do you mind if I look at that?
Yes, ma'am.
All right, Ms. Van Duzen, in the matter of the people of the state of Michigan versus Milton Rembert, file number 22-21191FH. I just had somebody pop into the waiting room. Let's see who that is. All right, in the court of the common pleas of Lucas County. Okay. All right,
But
so
if my fine need to be paid, I can have them pay the 23rd of February.
okay, you can give them that back. But give me 1 minute, all right? All right, so does that, I don't know who this gentleman is. Let me see. I gotta find out. I don't know who this gentleman is, Miss Van Duzen. I don't know if it's your client or not.
It should be Mountain, yes. I just talked to him.
So Mr. Moore made us aware of the fact that there's a violation of probation warrant. He was told to appear today, but Mr. Moore is in the room with the defendant right now. All right, no, still not connected, so. Okay. Do you need to talk to Bridget Reinhardt, Mr. Malaro?
I talked to her the other day. I think we're okay.
So Mr. Rembert still trying to connect. I'm going to take Miss Reinhardt. All right, this is Miss Reinhardt. Can you hear me?
Yes.
All right. I keep sending him a chat message to connect, but all right, this is in the matter of the people of the state of Michigan versus Bridget Susan Reinhardt, file number 21-20279FH. I have Salvatore Malaro appearing on behalf of Miss Reinhardt, and I have Isaac Sneed appearing on behalf of the people. This is a date and time scheduled for like the 5th or 6th pretrial. So at this point, barring a plea, where are we heading? I know the last time, several times we've been here, the last 4 times we've been here, Mr. Malaro, you've not been able to get information from the accountant, is that correct?
Yeah, it's been rather difficult, Your Honor. However, I spoke to Miss Meir about this case yesterday. And I know the court probably doesn't want to do this, but if we could adjourn this one more time, Miss Meir and I are going to get together in the very near future and see if we can come up with a workable resolution for all parties.
Do you want me to schedule that as a bench conference?
Yeah, that would be fine. I think that would work.
Miss Adams, could I have a bench conference time on a Wednesday around 11 a.m.?
Okay.
And the only reason I'm being pushy about that is, Mr. Blau, it is an older file.
I know, Judge, and I know and I understand the court's position, but we, I think, are pretty close to getting this worked out.
Judge, do you want it scheduled at 11, even though there are jury trials?
Yeah, that's fine.
February 22nd?
So February 22nd, he's gonna be here anyway.
Judge,
Right, Mr.
if I may, on the 22nd, Mr. Sullivan was scheduled. He's now resolved. And Miss Edmonds, we confirmed as a firm trial date, but shortly thereafter, Mr. Sneed had indicated that they're going to probably dismiss that file. So if that's the only two cases you have, you would not have any trials that day.
Well, okay, so we'll do February 22nd at 11 a.m. with for a bench conference. And Ms. Adams, could we do the notice on a bench conference? I think we do them on a bench. Yeah, we'll just send a notice out. All right, so February 22nd at 11. So Ms. Reinhardt, our next court date will be February 22nd at 11 o'clock. All right. Actually, I'm sorry, Mr. Malaro, can you just do the stip in order and set it for a bench conference at 11?
Yes, I will do that. And then Ms. Reinhardt, I'll get a hold of you soon after that conference, okay?
Unless you want her present for that.
I'll talk to her about it, Judge.
Okay, all right. Okay, so that takes care of you, Ms. Reinhardt. Thank you.
Thank you. Have a nice day.
You too. All right, I have a gentleman on a blue shirt on a Motorola. What is your name?
Milton Rembert.
All right, Mr. Rembert. This is in the matter of the people of the state of Michigan versus Milton Trey Rembert, file number 22-21191FH. Let's see, this is the date time scheduled for a show cause as well as a pre-trial. I have a motion in order to show cause filed January 18th of 2023, stating that Mr. Rembert has failed to drug test as directed on January 11th of 23 and January 14th of 23. It's my understanding there is also Mr. Moore. Where'd Mr. Moore go? I don't even have a PO. Hold on. Where'd he go?
Excuse me, Judge.
Yes, sir.
Were these charges in Lenawee County?
Well, all right. So, Mr. Rembert, the file that I just called, you have a charge of failure to stop at a scene of accident resulting in serious impairment or death.
Y'all got me confused with my son.
Let me look at your date of birth.
Judge, that is the wrong individual on camera there.
Y'all talking about my son. I don't even live in Adrian.
Okay, you don't know. Okay, so Ms. Van Dusen, you don't have a number for your son, do you?
No, I was, when he called me and said I had court, I was kind of baffled. I didn't know what was going on.
Well, Mr. Rembert, sorry about bothering you and enjoy your day.
Hey, but if y'all are trying to charge me with something that my son did,
No, he just gave us your number.
He gave us, your son gave us your phone number, and that's why we called that number.
Oh, ain't this about a blip? Okay.
All right, Mr. Rembert, you have a good day.
All right, thank you.
Bye-bye. All right, so with regard to Milton Trey Rembert, the son, he has failed to appear. So, and he also has a warrant for violation of probation as well as the show cause. So, Ms. Van Dusen, unless you have a good reason otherwise, I will be issuing a bench warrant for his arrest.
Nope. I did my part.
Like yelling at him right now. All right, so I'm going to issue a bench warrant for failure to appear, and I'm going to set bond in the amount of $100,000 cash.
Thank you,
All
Judge.
right.
Thank you.
All right, thank you all. Okay. Miss Underwood, we got Mr. Dodson.
I'm sorry?
Do you have William Dodson?
That's correct, Your Honor.
All right.
The long-suffering case of Mr. Dodson.
Yep, he's been here this morning. So, all right, Mr. Dodson, can you hear me?
Ma'am.
All right, so this is in the matter of the people of the state of Michigan versus William Jarrett Dodson. We have multiple files. File number 2019-19390 FH, that's a violation of probation. Well, these are all violation of probations. So Mr. Dodson, Ms. Underwood, I just want you to know, he's been here since like 8 o'clock, so he's very good about that, and I let him go for a while. So Ms. Underwood represents Mr. Dodson on the probation violation. So Ms. Underwood, how do you wish to proceed today?
Well, Your Honor, these have been outstanding for a while. And as I recall, there were drugs. Hang on.
Well, the allegation is violate terms of probation by possessing a double-edged knife, which is illegal, and crystal methamphetamine. So those are the allegations against him on all of these files.
That's correct. And I believe they were sent out for labs.
Yeah, we were waiting to see if there were going to be any new charges.
And I have not heard anything since, Your Honor.
Mr. Sneed or Mr. Fleming, are you able to look and verify whether or not there is an investigation pending? Was it in Lenawee County? Was it?
I can do a search now, Judge.
Okay, so while you're doing that, Mr. Moore, I do have you back. So, Mr. Moore.
Yes.
It appears that Mr. Maureen was released from the Ohio jail. So he came here to try to pay on his circuit court stuff in the amount that was ordered, and it got applied to district court. So, I can't really blame him for that.
Right.
If I pay it for today.
Hold on. So what he's asking for is for me to make sure he has a PR bond and give him 30 days to pay the $1,658.
Yes, ma'am.
You'll be able to pay that in 30 days?
Yeah, I might be able to do it today.
All right. So, Mr. Moore, I'm going to do that because I kind of.
Hold on 1 second here. Real quick, the balance is 1,858 according to Deb. But what we're saying here is that 1,658 got applied to district court money owed.
Yeah, they applied it to the district court. So here's what I'm going to say though. I am going to, let me look. He had a crime victim assessment, restitution, minimum costs, court costs. So you think you can, and it's $1,858. You think you can pay that in 30 days?
I had to check my account. If I pay it, is the case closed if I pay it for today?
If you pay it,
case closed?
Yes.
How much is it, ma'am?
$1,858. I mean,
I can do it. I can do it. I can do it within a week.
Okay. So, Mr. Moore,
today I just gotta wait for a transfer.
Hold on. So, Mr. Moore, what I'm going to do is release him on a PR bond.
Okay.
My paperwork. And then I'm gonna set this out a couple weeks, and if he pays off the balance owed, I have no objection to terminating his probation.
Okay,
Miss Adams, he is present, so can I set it on like a Thursday morning or something?
You say a couple weeks out, Judge?
2 weeks.
You've got 6 scheduled on the 23rd with drug court following that. I don't know if you want to add it to that.
What about the next day?
And then you have a neglect at 8 a.m., a 3, 9 o'clock, and a 10 o'clock.
Okay, on the 10th, what day was that?
Thursday is the 23rd and then Friday the 24th.
All right, so I'm gonna set this for February 24. We're gonna get you a notice at 8 in the morning, okay? So, sir, I'm gonna get you a notice of hearing today. I'm gonna release you on a PR bond to make sure there's no warrant. As soon as you pay this, okay, but he needs to make sure he goes to the 3rd floor. So not the 1st floor, not the kiosk, you need cash.
Yes, ma'am. I'm having it sent to my account.
Okay.
It's gonna take some time for it to clear.
No, that's fine, but listen to me, then you're gonna have to get cash.
Yeah.
And then you need to come to the 3rd floor of the courthouse and go to that clerk's office. As soon as you pay it, we'll revoke and terminate your probation and you won't have to come back. Okay?
Yes, ma'am.
So you wait for a notice of hearing. And we'll get that for you, but if you pay it all in full, you won't have to come back on that day, all right?
Yes, ma'am.
Okay,
It's being transferred today and I'll be here tomorrow morning.
okay,
okay, Mr. Moore, and when you do that, then bring that receipt over to the probation department so then we can proceed with the paperwork to close the case out.
Yes, sir.
so you
Thank
would
you.
pay down there, get your receipt, walk down the hall, the 3rd floor probation, and give them the receipt. Got it? Don't go to district court, okay? All right, so Mr. Maureen, we will get you a notice of hearing, and then you can go on your way, all right? Okay. All right, so Mr. Dodson, all right, so, Mr. Malaro?
Yes, Your Honor.
Go ahead, Mr. Dodson.
Miss Underwood.
All right, so Miss Underwood, what do we, I'm sorry, Mr. Steen, were you able to find out if there's any pending charges?
I did not see any pending charges.
Okay, Miss Underwood? I think I've lost Miss Underwood to another court. All right, so hold on, Miss Underwood is probably in another court, so give me just a moment. Mr. Malaro, do you have Hannibal?
I do.
I'm here.
Do you need a breakout room with Hannibal?
I do not.
All right, so Miss Underwood, Mr. Steen stated that in their records, it does not show that there are any pending charges for possession of crystal methamphetamine or the knife. So if he were to plead today, Mr. Steen, would that mean we would be assured there would be no further charges?
Related to this incident, Judge, I don't know what else to
Right.
input.
All right, so Miss Underwood, what would you like to do?
Let me talk to Mr. Dodson, Your Honor.
Mr. Dodson, I'm gonna put you in the breakout room with Miss Underwood and. All right, thank you, Mr. Maureen.
Yes, ma'am. Thank you.
Thank you.
Sorry.
No, you have a good day, sir. All right, you should have gotten an invitation to join that breakout room, and Miss Hannibal, you grab your file. All right, this is in the matter of the people of the state of Michigan versus Lisa Marie Hannibal, file number 23-21232 FH. There's Salvatore Malaro appearing on behalf of Ms. Hannibal, and I have Isaac Sneed appearing on behalf of the people. This is the date and time set for arraignment in this matter. Mr. Malaro, do you waive the reading of the information?
Your Honor, we would acknowledge receipt of the information, waive its reading in open court as to counts 1 and 2, waive any defects as the time and place of service. I would enter a plea of not guilty on behalf of Ms. Hannibal. Ask the matter be set for a pretrial. She has a pretrial already scheduled for February 15th. We'd ask this be set for that date.
All right, so I will set this matter for a pretrial on February 15th at 8:30. And I will enter a plea of not guilty on her behalf. So Ms. Hannibal, we will see you back on February 15th at 8:30 in the morning for a pretrial. And Mr. Sneed, just for my notes, has a plea offer been made on this file?
I did not see one in the file, Judge, no.
Okay. All right, so we'll see you back on that day and your bonds continued. Thank you, Ms. Hannibal.
Thank you, Your Honor.
All right, so do you have Samantha Ladd, Mr. Malaro?
Yeah.
Becky, could you see if the jail could get Miss Ladd? Mr. Dagger Margosian needs Miss Carr, and I have Israel Vila is a bop. I have Kyle Roberts, which is Miss Underwood. So if we could start with anybody.
Judge, I never received the VOPs for Carr or Vila. I don't know if probation has them.
I thought you brought me the file. I have a motion affidavit and bench warrant for Carr.
Yeah, that's just the fail to appear, not the VOP.
Is she a bop too?
Apparently.
Okay, I'm gonna text Ms. Tusky. All right, I just sent a I just sent a message to Ms. Tusky. All right, so if we could then just start with Samantha Ladd or Kyle Roberts, that would be awesome. All right, so we're back with Mr. Dodson. Miss Underwood, have you had a chance to speak with Mr. Dodson?
Yes, I have, Your Honor. At this time, we wish to set this matter for a hearing, Your Honor.
All right. How long do you need, Miss Underwood? A week?
That should be sufficient. Or no, I'm sorry, Your Honor. It would have to be 2 weeks. I'm out of the office next week.
And plus, I think Mr. Sneed, how many witnesses will I don't know, would people have to arrange for police officers as well?
I'll have to review the file for the witnesses, Judge.
All right, I'm going to set this out like 3 weeks. How's that?
That's perfect.
So, Miss Adams, I'm looking for an hour. Not on a Wednesday morning.
Judge, I believe she's on the phone. Might just be a second.
Okay. So we'll just wait a second. Mr. Malaro, Shane Hopkins.
Yes.
Do you know where he is?
He's supposed to come to my office at 11 o'clock.
All right, so that is right. That's 11. We did this one. Let's see. Kyle Roberts is in jail. So let's see. Samantha Ladd is in jail. How about Louis Mota? So in the matter of the people of the state of Michigan versus Louis Martin Mota, file number 20-19945FH. I have Mr. Malaro representing Mr. Mota. And I have Isaac Sneed on behalf of the people. I do show this is actually a violation of probation, Mr. Malaro. I apologize. So I have looks like the public defender's office was appointed, Ms. Underwood. Did you have Mr. Mota?
Judge, I have Mr. Mota.
Oh, okay. So we have a violation of probation. And I've had multiple notices go out for him to appear today. Is he in your office?
He's in custody.
Ms. Adams, is Mr. Mota in jail? Not on my jail list.
Mr. Mota, I do not see him on there, no.
Could you verify with the jail whether he's in custody? And then I need Ms. Adams, because you know I always ask you for 7 things at the same time. I need like an hour hearing at least 3 weeks out for Mr. Dodson.
Okay.
Last I knew he was in custody, Judge.
Right. He just wasn't on our jail list. He might be. Never know.
So March 7th, we have a week jury trial starting with Mr. Goldstein. So I don't know.
What day is that?
Starts on March 7th.
How many days is it?
1 week. So it looks like we have that whole week, and then there's.
So we could do it maybe. How about the week of March 13th?
And then you have 3 jury trials scheduled that week. Day 3 would be March 16th if you want to do it that day.
March 16th, what time?
So you do have drug court as well, so if the afternoon works.
1:30, 1:30. Yeah. So Miss Underwood, March 16th at 1:30 for a VOP trial.
Thank you, Your Honor.
All right. So.
Is this on Mr. Dodson?
Yeah.
And is
All
that
right,
in
so
person, Judge? Sorry.
That'll be in person. So we will set this for a mock trial on March 16th at 1:30. And that'll be in person. And so Ms. Adams will mail the notice out on that. So Mr. Dodson, we'll see you back here on March 16th at 1:30 in person, all right? Okay. All right, thank you, Ms. Underwood on that, and Mr. Dodson, you're all set.
Yes, ma'am.
And let me know what you hear about Mr. Mota. All right, who do I have joining me from the jail?
Samantha Ladd.
All right, paperwork. All right, this is in the matter of the people of the state of Michigan versus Samantha Diane Ladd. There are 4 files and we have 1 arraignment. The arraignment is on file number 23-21239FH, and the other files are set for pretrial today, and those are files number 22-20961FH, 22-20962FH, and 22-20963FH. And we have Salvatore Milaro appearing on behalf of Ms. Ladd and Isaac Sneed appearing on behalf of the people. Mr. Milaro, on file number 23-21239, do you waive the reading of the felony information?
Yes, Judge, at this time, we'd acknowledge receipt of the information, waive its reading in open court, waive any defects at the time and place of service, and as to counts 1, 2, 3, 4, and 5, my client would stand mute and ask that a pretrial be set in a short duration. She has the other matters as well. And I think now that they're all together, if we have a earlier pretrial than later, we could perhaps get these all resolved.
Okay, so I will enter a plea of not guilty on behalf of Ms. Ladd on file number 23-21239FH. And we will set all of these matters for a pretrial on April 5. At 8:30 in the morning. So Mr. Malaro, we automatically generate the notice for pretrial on the arraignment file, but you'll have to do a stipend order for a pretrial being adjourned on the other 3 files, okay?
Correct. Yeah, and may we address bond on these cases, Judge? Briefly.
Hold on one
Take 2
second.
minutes.
Let me write this in. 5, 8:30. All right, Mr. Malaro, you may address that.
Yes. So Judge, I'm very familiar with Miss Ladd. She is a lifetime or long-term resident of the county. I know that she has some issues with appearing, but now that I got all these cases together and spoke to her about them, when we waived this case up here, she assures me she will appear at all court appearances with one caveat. She's currently expecting the birth of her first child. I think it's imperative for her and important for the court to note that she wants to be able to provide the best option for her child. And I think that's possible if she were to be not in custody. She informed me she would keep me apprised of that status while this case is pending and we get it worked out. So we'd ask the court to reduce the bond to some type of personal recognizance with perhaps a reporting requirement with Mr. Coast, so that the court can keep apprised of her situation and she can provide the best option for the birth of her child. That would be our.
How far along is she?
What's your due date, Samantha?
I'm due April 1st.
April 1st.
All right, so Mr. Sneed, in this case, she's charged on her new file with multiple counts of assault with a dangerous weapon with an incident date of August 15 of 22. And then her other 3 charges are possession of methamphetamine, police officer resisting and obstructing. She has had some issues with failure to appear. And what is your position on that?
Your Honor, I know the court is well familiar with Miss Ladd. I would defer to the court's discretion regarding those conditions in light of her due date and presence at the county jail.
Well, I don't feel that pregnancy is enough of a reason to release someone from Malone County Jail. She'll actually receive good prenatal care at the jail. But these offenses stem from March until August, with the last group being assaultive. And she has had some history of not appearing for court. So I'm not going to release her on a bond. Her bond will be continued. Because I do find that she's a danger to society based upon these charges. All right, thank you, Ms. Ladd. We'll see you back on April 5th at 8:30 in the morning.
All right, thank you.
Thank you, Judge.
Thank you. All right, so I think I took care of Mr. Dodson. So let's see what we got left. Hopefully we can get Mr. Roberts.
Judge, Mr. Mota is in jail and they're getting him next.
Okay. Zach, do you want to come grab some of these files? They're like getting kind of ridiculous.
So I was looking for him on time. He didn't want to drug for it. Can you do anything to get misdemeanor or something else to raise with him?
Mr. Moore, I did have communications with Ms. Teskey on Ms. Carr.
Yes, so Ms. Carr hasn't continue not to, failing to report for her pre-sentence investigation. So if we could just leave her in jail, we get that completed.
In the military, but he didn't qualify for veterans authority. He didn't serve on them. We didn't have enough time to serve.
All right, so
Well, they probably wanted to see who serve enough time and actually serve who did serve probably being better than others.
I don't have to arraign her on anything today?
No, well, we just had, so she had the bench warrant for failing to appear, I believe, right? That was what was I was trying to get for sentencing.
Yeah.
So, yeah, no.
Your Honor, is this for Aaron Carr?
Yeah, there you are. So I show she was picked up and the jail list says that it was a bench warrant for obstructing justice, show cause failure to appear. So Ms. Teskey said that she did not appear for her PSI. So I have a show cause for failure to appear on December 28th.
The other warrant would be, I think she was failing your bond conditions, maybe not doing her drug testing too.
Is there a case number, Judge? Because I had represented
Yes.
Ms. Carr.
Hold on. So it's People of the State of Michigan versus Aaron Michelle Carr, file number 22-20951FH. As I look through the file on December 28th of 2022, there's a motion affidavit and bench warrant for failure to appear on December 28th of 22 for a show cause. I look back, somebody posted quite a hefty bond for her back in December. That was nice of them. But she also has a show cause for missing her drug screens on November 7, November 22nd, November 25, and testing positive. There was a bench warrant back on October 25 for testing positive. So she's got like just multiple bench warrants on this file.
Judge, the only thing I wanted to address was the matter of sentencing. She's on a delayed sentence. So she's already essentially been sentenced. So that's the only thing I didn't fully understand, but I
Right.
understand.
So she did, well, she pled guilty to the contempt of court. But the problem is, I don't know if this is true, Ms. Teskey said she didn't show up for the PSI.
My guess
So
is
if I
that you delayed the sentence at the time and she took the plea and then she needed to go complete the PSI and she just never did that.
Right, they still got to report and do the PSI, so I would have instructed her to do that. So I can, Ms. Teskey will be here tomorrow. Becky, how many things do we have in the morning? I don't think we have a whole lot, do we?
Tomorrow morning you have an 8:15 sentencing and then nothing till 1:30. Oh, I'm sorry, you have drug court. I apologize.
Right. So what if I set this for tomorrow morning at 8:15? Ms. Teskey will be here. Are you available, Mr. Dagger-Mergosian? Or do I just?
I am available.
It sounded really reluctant.
Well, I'm available, Your Honor. Thank you.
Okay, so we'll rearrange her on all of the whatever, and we'll set that for, no, actually, yeah, we'll set it at 8:15, 8:30 tomorrow morning. And that'll be the 9th. Gosh, so 2/9 at 8:15. All right. So we'll see you back then on Miss Carr. All right.
And Your Honor, is that on what specific, is that on the 3 open cases she has?
I just have.
Judge, there's also a bench warrant on 2022-20952 that they have not given me yet.
So it looks like it's both of her files.
All right, and there should be a third file number 2221040. And I do have a PSI on file ending in 951. So we can just straighten this out and address it tomorrow, I guess.
Yeah, we'll figure it out tomorrow. Thank you, Mr. Dagger.
Thank you.
Um. I don't think I have anybody not in jail that I could issue bench warrants for. Waiting on the jail. They'll be here in a minute. They got a couple people to shuffle. Random, see you dance. Oh, it was funny. You were dancing on a video this morning, by the way. I was checking something on the live stream from today, and there's one scene where you're like dancing a little bit in your office.
Oh, I just danced for the phone going off, Your Honor.
That's funny.
I'm gonna wait for you now. On TV. I'm gonna take about a minute. Well, you want to run to the restroom while we're waiting for the gym? Okay. Is that language you wanted? If you wanted it,
Oh,
but it's
yeah.
gotta go back in the file.
Oh,
It's like on the last page and a half.
All right, I'll just make a copy of it then. Good job.
Yeah, you're waiting for the volume. Huh? You never come. I do. I know. So literally any platoon I end up on, I still have fun. Literally the only thing. Like, no. And then.
Yeah.
Oh.
No. They're not sitting there. They're not sitting down. There's nobody sitting in the room yet.
Good times. Oh, oops. Becky, I'm gonna print off a search warrant, so I'll get it when I take a recess. Is there anybody in the jail room, or I hear voices? Is there anybody in the jail room?
Right, because I remember, and like I said, you know what I mean, like when you look at everything, we break everything down with what you changed 3 times already. But you said that I never did anything for another, and like that, now all of a sudden, it's somebody do something to you, I actually really kind of go, he said, I don't want to go home.
All right, if somebody's called in on an iPhone device, can I ask your name, please?
Tiffany Armentrout.
Oh, okay, good. So you are actually though, Tiffany, set for 11:30.
Oh, okay. I will zoom back in later. Thank you. Sorry.
All right, thank you.
Bye-bye.
Bye. Miss Underwood, with Mr. Morin, Maureen, we set that out for him to make a payment, so we won't be seeing him again this morning.
You set that out for what, Your Honor?
So he made a payment, but it got applied to district court because he paid it in the wrong place. So that's fine. But he said he could pay this off in like 3 weeks. So I adjourned him out. I didn't even arraign him. 'Cause he
Okay.
said so.
Okay,
you
just so
don't have
I
that-
know what to put in our file.
So what are you waiting on now?
I don't think I have anything left.
Okay, all right, well, thank you.
Thank you.
Bye.
Bye.
Becky, I'm going to reprint that search warrant. So you can discard the one that's already there. I'm sorry.
Okay.
Becky, what has the jail said? I think all we have left is Roberts.
I will call them again.
And Judge, I'm here for Hopkins at 11.
Yep. I mean,
Oh,
we can
okay.
do that. Sam Malaro is not here, so.
Yeah, we need Sam.
Judge, did you still want Mota though, or no?
Yeah, we need Mota too. Yeah, okay. Becky, can I get that search warrant, please? I'm sorry.
Fourth grade, yeah. There you are.
All right, Mr. Mota.
Yes, Your Honor.
Let's see if I can get your attorney. Oh, here he is. All right. Mr. Malaro, you represent Mr. Mota, right?
I do, Your Honor.
All right, this is in the matter of the people of the state of Michigan versus Louis Martin Mota, file number 20-19945FH. I have Salvatore Malaro appearing on behalf of Mr. Mota. This is a violation of probation file. The allegations are that he violated the terms of your probation with new charges. So, Mr. Malaro, do you have an update?
I do, Your Honor. Mr. Mota has retained counsel on the underlying charge. It's my understanding that a preliminary exam is scheduled for March 17th in district court. So I'd ask to adjourn this out past that date, probably beginning of April, I would say.
All right. So, Mr. Mota, I am going to set this out to April 12th. For the probation violation for a pretrial, and that'll be at 8:30 in the morning. And Mr. Mota, who'd you hire?
I have Sam Bennett, Your Honor.
Okay. If he's going to be representing you on this file as well, if he calls the office and wants it combined, we can do that, all right? Otherwise, we'll see you back on the violation of probation on April 12th at 8:30, okay?
Okay, thanks, Your Honor.
Your Honor, do we do the stip in order on that? Or do you?
No, it's a
Violation.
box. It's a box, so Miss Adams doesn't notice.
Okay, all right, thank you.
All right, thank you.
Thank you, Mr. Mota.
No, thanks, Your Honor.
Let him know we need Mr. Roberts if you can.
Okay, I will.
Thank you.
Yeah, they need Mr. Robert.
Mr. Malaro, I do have Miss Meir here.
Yes,
So give me a moment and I'm gonna put the courtroom in the waiting room. And I'm gonna